You believe a doctor was careless and caused you significant harm and injury. You find the best attorney you can to see whether or not you have a valid medical malpractice case. Your attorney sends your records out to a medical expert who says, "I'm sorry, I don't see that this client has a valid basis for a case." And you say, "Wait a second, I think there are other medical records this expert has not seen. If I get those records and now submit it to the expert through you, will you have the expert look at it again? Is it possible he'll change his opinion?" You want to know the answer to those questions? Come join me for a walk along the beach as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, you suffered significant harm and injury, you believe, because various doctors were careless and did not do what they were supposed to do. You believe that they violated the basic standards of medical care. And now, you find the best lawyer you can, and now you go to him, and he goes ahead and obtains your medical records. He then has to take those records and submit them to a medical expert to evaluate whether or not the treatment you received was within the standard of care, or whether the treatment you received was a departure from the standard of care. In this scenario, the expert reviews the records and determines, you know what? It is my opinion that no, there is no valid meritorious case here. And now he relays that information to your attorney. Your attorney calls you to give you the bad news. And now, as you're listening to the attorney discuss what the expert told him, you say, wait a second, did the expert have these additional medical records? If it turns out that the medical expert that your attorney hired did not have all of the necessary records to reach an educated decision about whether or not you have a valid meritorious case, now, if you now learn and remember at this later time that yes, there were additional records and you think it's going to make a difference, now if you go ahead and get those records and now give it to your attorney and the attorney then submits it to the doctor, can he do that? Many times the answer is yes. However, there's a big caveat here, there's a big however. If your time in which to go ahead and file your lawsuit has expired, has now lapsed, it wouldn't make a bit of difference if the expert reviews those additional records at that point. Why? Because once the time limit that you have to file a lawsuit has now expired, that's it, you're done, your case is over and will never be able to be brought. That's known as the statute of limitations. So let's say you go to an attorney. The attorney now takes many months to go ahead and obtain all of your records, and now he sends it off to his expert, and oftentimes it will take a good number of months for the expert to review and digest all of the records that your attorney has sent. The clock is ticking because you have a limited time within which to bring a lawsuit against a doctor or hospital in New York. And if that time expires, now you have a significant problem and you will likely never be able to bring a case. So if you are still within the time frame in which you can bring a case, and it comes to light that there are additional medical records that you and your attorney believe would make a difference to the expert's opinion, then yes, you should get those records. Your attorney should make efforts to get those records as quickly as possible and send it off to the expert to re-review and re-evaluate. And if you are still within that time frame and now the medical expert changes his or her opinion and now says, yes, based upon these additional medical records, it is clear to me that yes, your doctors violated the standard of care, and as a result of that, you suffered significant harm and injury. In that instance, you going ahead and recognizing and remembering that you have these additional records that would make a difference, yes, in fact, that would have made a difference. However, there are many instances where additional records are provided and the medical expert turns around and says, no, this doesn't change anything. My opinion is still the same, in which case you have very limited options. Your attorney can either go ahead and invest in trying to find another medical expert who thinks differently or reaches a different conclusion, or you can ultimately take your case and try and go to another attorney to see if they might have a different expert who has a different opinion than the one that your current attorney and his expert had to say. So why do I share that with you? Because this does happen from time to time. You and your attorney believe that you have all the necessary records to evaluate a particular case, and now you get a negative review, and you say, wait a second, I do remember I saw this other doctor, and I remember he told me X, Y, and Z. And now in that instance, you go ahead and get those records, you have them reevaluated, and now his opinion totally changes and says, yes, now based upon these additional records, guess what? You do have a valid case. Thank you so much for getting those records. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.